A basic overview of the history of protection and indemnity, or P&I insurance, as a foundation for the remainder of the programme. Protection and indemnity insurance. In times gone by, the owner of a ship was often the owner of the cargo. If this was not the case, the ship owner secured indemnity from the cargo owners in the contract to carry the goods. The right to compensation, in various countries, was not well developed with respect to ship owners' liability for personal injury and damage to property. While hull insurance began in the 16th century, P&I insurance did not develop until the 1850s. At that time, ship owners saw a need for cover of third-party contractual liabilities and other risks not covered by hull insurance. Developments since 1850. From 1850 onwards, however, third-party and contractual liabilities of ship owners increased. Those persons with an interest in the cargo attacked the indemnity clauses of freight agreements and gradually gained the goodwill of the courts. Ship owners' liability for damages caused by his employees arose as society became increasingly aware of the ship owner's responsibilities as an employer. Around this time, too, the great increase in passenger and emigrant traffic led to claims by passengers themselves or their survivors. This resulted in a considerable increase in liability for the ship owner and a need for insuring this risk. The result was the establishment of the first protection association, the Ship Owners Mutual Protection Society, formed in England in 1855. It was intended to protect ship owners against liabilities for loss of life, personal injury and collision risks that were excluded from marine insurance policies. In 1874, the risk of ship owners' liabilities for loss of or damage to cargo carried on board was added to the cover provided by a protection club. The ship owner would thus be indemnified for costs and expenses arising from loss of or damage to cargo, for which the ship owner was legally liable. Subsequently, the distinction between protection and indemnity virtually disappeared. Within the past decades, the development of P&I insurance has been remarkable. It is now as important for the ship owner as any other insurance. Most countries now require P&I insurance to be in place before a vessel can sail, and the ship owners cannot afford to ignore this requirement. P&I associations are mutual insurance societies or clubs, many of which have been in existence since 1874. In fact, you will see the terms association and club both regularly used today. They are the same thing in the context of marine insurance as discussed in this module, but for continuity, the term association has been used throughout this training program. They enable ship owners to protect themselves against the many legal liabilities to which they are exposed in the course of their business. The associations derive their economic strength from a system of mutual support. They are non-profit organizations which collect premiums and, apart from the fixed premium associations, levy supplementary charges, if necessary, in order to pay claims and to cover administrative costs. The owners of ships registered with a particular association are called members, and they are represented within an association by an elected committee. As we shall see later in this module, membership includes both ship owners and charterers. The committee employs a management to run the association on a daily basis. Protection and indemnity insurance covers ship owners, ship operators, and charterers against liabilities arising directly out of the operation of a vessel. The insurance covers the ship owner's liabilities to third parties and supplements the hull and machinery insurance. Of this chapter are to understand the structure within a typical P&I association, understand the functions performed by the various departments within a P&I association, and to understand exactly what is covered by P&I insurance. A P&I association typically has a number of different departments, each of which performs a specific function. These may be as follows. Click on the buttons for more information. Much of the everyday work at the P&I Association involves answering enquiries from members on current and ongoing problems. While the greater part of an association's routine work focuses on the investigation and processing of claims, the P&I team also delivers ongoing advice on the prevention and limitation of the membership's liabilities by means of handbooks, circulars, newsletters and websites. The P&I associations also regularly arrange meetings with clients and deliver seminars to assist in understanding risk management. A ship owner or a charterer wishing to enter a vessel into a P&I association provides the association with relevant information about the risks to be insured. The P&I association issues a certificate of entry merely as confirmation that the vessel is entered with the association. The certificate of entry contains extracts of the insurance conditions and refers to the association statutes and rules in force at the time in question. A ship owner or charterer becomes a member of a P&I association by insuring a vessel with that particular association. The entry is valid until cancellation, withdrawal or transfer to another P&I association, or until the vessel is sold by the owner or wrecked. The following factors will influence the premium that an owner or operator will pay for insuring his vessel through the association: the tonnage or size of a ship, its age, flag and type, the trading area, the type of cargo or cargoes to be carried, the nationality of crew, type of crew contract, and whether the crew is supplied directly by the ship owner or through a manning agency, and the historic performance of the ship, its crew and ship management. The resulting premium will typically comprise two parts: an advance premium, agreed between the owner and association for an insurance year, subsequently adjusted depending on the individual performance by the vessel owner, and supplementary contributions, except in the case of fixed premium associations, to be paid at the end of the policy year and based on the performance of the whole membership of the P&I association. These contributions are levied according to the principle of mutuality, by which the members share each other's risks. They are calculated to the extent necessary only to achieve a balance over the year. Liabilities incurred by ship owners occur throughout the world. The legislation and legal practice, therefore, varies accordingly. Most P&I associations are, nevertheless, and with the consent of their managers, willing to cover a ship owner for any legal liability, irrespective of the applicable legislation. In short, P&I cover generally has no geographical restrictions. A P&I association has a large staff of claims adjusters within the organisation and has also appointed correspondents in ports worldwide. These correspondents work in close cooperation with the ship's agent in such matters as arranging surveys, appointing lawyers if legal proceedings are started, and making arrangements for the repatriation of stowaways where applicable. The centralised claims adjustment through the association helps to develop the experience and know-how required to guarantee effective and rational defence to counterclaims made against the ship owners. Between them, the group of major P&I associations, commonly known as the International Group of P&I Clubs, covers almost 90% of the world's merchant fleet, sharing major claims and buying reinsurance against claims for catastrophic events. Please now familiarise yourself with the scope of cover in the following three major areas. Click on the buttons for more information. P&I insurance covers personal injury, loss of life in respect of crew and third parties, and operations to save life at sea, medical, hospital, funeral and repatriation expenses in respect of sick or injured members of the crew, repatriation costs, unemployment indemnities, and loss of effects of shipwrecked crew, expenses in connection with stowaways and refugees, and extraordinary expenses incurred in cases of outbreak of plague or other diseases, and quarantine and disinfections expenses. P&I insurance covers loss of or damage to any other ship, boat or craft, or to property on board them, so far as such liability is not covered under the ordinary hull policy. Damage to any other vessel or property thereon without actual contact, such as from wash damage. Damage to docks, piers, jetties, buoys, cables, or other objects of a like nature, and property thereon. The cost of compulsorily raising, removing, or destroying the wreck of an entered ship, insofar as such liability is not covered under the ship's hull and machinery policy. Loss or damage for which a member may become liable under an indemnity given to the owners or operators of tugs, craft, cranes, or other appliances used for towing, loading, or discharging, insofar as such liability is not covered under the ship's hull and machinery policy. And oil or any other polluting substance escaping from an entered ship, resulting in loss, damage, or contamination, for which the member may become liable. P&I insurance covers claims for loss, short delivery, theft of or damage to goods intended to be or being or which have been carried in the entered ship. Fines imposed by governments or custom authorities in respect of short or over-delivery of cargo, smuggling, desertion, presence of stowaways, breach of immigration regulations. A cargo's proportion of general average and special charges not recoverable by reason of a breach of the contract of carriage. The costs of defence in a government or other inquiry incurred with the approval of the association, and in any other case which the association considers involves a question of importance or principle to the members, and third-party liability in respect of owned or leased containers or other transport devices. Listen carefully to this account of an incident, as you will be asked questions on it in the next 2 pages. Your vessel loaded a full cargo of coal at Hampton Roads, Virginia, United States, for discharge in Japan. A few days after the vessel's departure, there was a sudden explosion in cargo hold number 5, killing 3 crew members and injuring 2 others. As a result of the explosion, the hatch covers were blown off the vessel, and there was additional structure damage to the vessel as well. The vessel immediately diverted to Cape Town as the port of refuge, and the owners declared general average. When approaching Cape Town, the vessel was met by a Coast Guard helicopter, which brought the injured crew members to the nearest hospital. After the vessel had carried out temporary repairs in South Africa, she resumed the voyage to Japan. This part of the voyage was uneventful, but in Japan, the cargo receivers claimed that there was a shortage of almost 200 tons. There was no evidence that the alleged shortage was a result of the explosion. During bunkering operations in Japan, an oil spill unfortunately also occurred. Based on this account of the incident, please review the consequences listed below and select those where the costs would be covered by the P&I insurance. Based on this account of the incident, please review the additional consequences listed below and select those where the costs would be covered by the P&I insurance. chapter are to know the general circumstances to which P&I insurance will apply and what a ship's master's responsibilities are under those circumstances, and to have a general understanding of how P&I insurance applies to particular areas of a ship's business and operations. Within the area of P&I insurance, there is a great and ever-growing need for education in loss prevention. Most P&I associations have a good system in place for assisting their members to understand loss prevention and the advantages of a proactive policy towards it. In many areas, the members hold the key to loss prevention in their own hands. Planned maintenance schedules and competent crews contribute not only to safe and efficient ship operations, but also to a significant reduction in the incidence of avoidable claims. The following lessons are intended to complement existing communication with members relating to loss prevention. They are not a substitute for direct contact with the association, however, and the master should always contact the association's local correspondent whenever in doubt on P&I related matters. The terms and conditions of the insurance cover provided by a P&I association are defined in the respective association's rules, which are usually updated annually. In addition, most P&I associations maintain a website, often with a secure members area, and publish circulars, loss prevention bulletins, and magazines containing regular features and information on P&I matters. Further details may be found in the various handbooks and special manuals published by P&I associations. Whenever accidents or incidents occur which may involve the association's liability, the master should immediately inform the ship owner or operator and obtain instructions. A detailed written report on the incident should always be submitted to the owners as soon as possible. The report should incorporate the correct sequence as the events occur, accompanied by photographs and/or hand-drawn sketches where applicable. The master should also inform the association's nearest correspondent. When reporting an accident or requesting assistance, it is important that the master provides precise information about the incident and the type of assistance required. Click on the buttons to learn more about the master's duties at the loading port, during the voyage, and at the discharging port. The master must ensure that cargo is loaded, stowed, and secured carefully, ensuring the safety, trim, and stability of the ship. This is also a usual charter party requirement. The cargo must be stowed in such a manner that it can be carried without being damaged and without causing damage to the other cargo or the vessel's structure. The master must not only ensure that the cargo is properly carried and cared for during the voyage, but should also document the steps taken to care for the goods. Log entries must be made as carefully as possible and should contain all relevant details, including, where applicable, cargo temperatures, tightening of cargo lashings, ballast exchanges, pressure readings on liquid cargo tanks, and the integrity of the inert gas system. Weather forecasts should be checked daily, or more frequently if conditions demand, and the voyage should be planned accordingly. Whenever a ship encounters heavy weather during the voyage, and the master considers it necessary to reduce speed and/or to make course corrections, these details should be entered in the log. During the ocean voyage, all lashings and shoring should be regularly inspected and tightened as necessary. Temperature and ventilation records should be kept, and appropriate remarks entered in the logbook. If the master is aware of or suspects that the cargo has suffered any damage during the voyage, he should notify the ship owner or operator and the association's local correspondent as soon as possible, so that a survey can be arranged as soon as the vessel arrives at the discharge port. Whenever pollution occurs, refer to the Vessel Response Plan, or SOPEP, and follow the reporting requirements and practical steps it outlines. Oil pollution cleanup and associated costs are covered under P&I insurance. The issue and use of bills of lading often gives rise to difficult questions of law and practice. In any case of doubt or uncertainty, the master should always consult with and take instructions from the ship owner or operator. The master must be thoroughly familiar with the following aspects of administration and practice in respect of bills of lading. Click on the buttons for more information. When a shipper provides cargo for carriage on a ship or delivers cargo into the custody and care of a carrier, the shipper is entitled to receive a bill of lading, unless there is an agreement to the contrary. The shipper may receive a received for shipment bill of lading or a shipped on board bill of lading, depending upon the situation. In addition to being a receipt for the goods, the bill of lading has three important functions. It provides legal evidence of the terms of carriage. It contains documentary evidence of the apparent condition and the quantity or weight of the goods at the time of shipment. It identifies the owner of the goods. The description of the cargo contained in the bill of lading is treated as evidence of the condition and quantity or weight of the goods at the time that they were received, loaded or shipped by the carrier. Accordingly, it is essential to ensure that this description is correct. This is particularly important as the bill of lading becomes conclusive evidence once it has been endorsed or transferred to a third party. In practice, shippers may be reluctant to accept bills of lading which do not describe the cargo as being clean on board, in apparent good order and condition. Certain shippers may even offer masters a letter of indemnity in exchange for the issue of clean bills of lading. However, as a matter of law, the issue of a clean bill of lading for damaged goods constitutes fraud. In addition, in such circumstances, any letter of indemnity is legally unenforceable and effectively of no value. The master should insist that the bills of lading are properly claused with remarks reflecting the true condition of the cargo, as is detailed in the mate's receipt or receipts, where applicable, or other document or documents consistent with the nature of the trade or cargo carried. The master will normally sign the bills of lading. If it is not possible for the master to sign the bills of lading at the loading port without delaying the ship, authority may be given to an agent, nominated by the owners for this purpose, to issue the bills on behalf of the master. If such authority is given to an agent, the master must immediately advise the owners of the agent's terms of authority. The agents should only be allowed to sign bills of lading on behalf of the master if he has agreed to all details, including the loaded quantity or weight. Where agents sign bills of lading on behalf of the master's letter of authorization to do so must specify that the bills of lading are claused in accordance with mate's receipt or receipts, where applicable, or other document or documents consistent with the nature of the trade or cargo carried. A bill of lading is traditionally issued in a set of 3 originals. When one original bill of lading has been concluded, in most cases the remaining originals become null and void. Accordingly, the master is bound to deliver the cargo to the holder of the first original bill of lading duly presented at the port of discharge, unless he is aware or has a reasonable suspicion that the ownership of the cargo is in dispute. The master should never release cargo to the consignee without production of the bill of lading, unless he has received explicit instructions from the owners to do so prior to the commencement of discharge. P&I associations will not cover liability arising out of the delivery of cargo without production of the bill or bills of lading. It is therefore important for the master to strictly follow the owner's instructions. Where owners wish to deliver cargo without the production of the bill or bills of lading, it is recommended that they obtain a letter of indemnity countersigned by a first-class bank prior to delivering the cargo. If the letter of indemnity is to be subject to a limitation of liability, it is recommended that this limitation should be no less than 200% of the cost, insurance and freight value of the cargo. The master will not be involved in this process and will be instructed by his owners or P&I correspondents accordingly. Ship owners or operators are obliged to maintain a safe working environment on board the vessel at all times. If crew members, passengers or shore personnel are injured on board the vessel or in its vicinity as a result of the failure to maintain a safe working environment, the owner or operator will be held liable. In certain jurisdictions, such as the United States, awards for personal injuries can be extremely high. In order to minimize owners or operators' exposure to personal injury claims, the master must be constantly vigilant against defects in the vessel, which may affect the safety of the working environment. Click on the buttons for more information. In the event of an illness or injury to any person on board while on the high seas, the following important issues must be considered. The best possible medical care must be provided until the person can be taken ashore and hospitalized if necessary. If the person's life is in danger, the master should consider diverting the ship to the nearest suitable port to obtain proper medical treatment. The master should seek medical advice by any appropriate means, such as email or radio communication, and keep a careful note of any advice received. If the injury was caused by a failure of part of the ship's equipment, the master must ensure that the damaged part is retained for future inspection, or call in a P&I surveyor to investigate the incident, inspect the damaged part, and prepare a survey report. Ensure that the incident and/or accident is properly recorded. Identify the injured party. Confirm whether the person is an employee and in what capacity he or she is working on board. This is relatively simple for crew members, but may be more difficult if it involves shore labour in port. Claims for personal injury to a stevedore, passenger or other person on board who is not a member of the crew may be submitted months and even years after an incident. Therefore, the master should ensure that in the event of an incident on board, the incident be properly recorded in the correct sequence, as the events occur, accompanied by photographs and/or hand-drawn sketches. Such reports must be preserved. Fully document all circumstances surrounding the accident. Follow the company incident or accident reporting procedure and complete the appropriate form or forms. Document all medical treatment administered on board, including any drugs or other medicines used. Stowaways, migrants and refugees are an ever-present problem in certain areas of the world. While the master is under certain humanitarian obligations, significant costs can be incurred, particularly if procedures are not properly followed. With stowaways, the ship's officers can also take precautions to prevent them gaining access to the ship in the first place. If stowaways are discovered on board, the master should send detailed information to both his owners and the P&I Association as soon as practicable, in order that the required administrative processes can be commenced. The association will assist in the proper reporting of such persons to the authorities at the port of destination. P&I associations routinely guide their members on the handling of stowaways, migrants and refugees. It is important that ships' officers associations generally remain covered when arising out of incidents of piracy. These liabilities are most likely to involve loss of life, personal injury, illness, crew substitution, repatriation, loss of personal effects. Liabilities could also, under some circumstances, potentially extend to pollution, possible wreck removal, and cargo liabilities in the case of a shipowner's contributory fault or negligence. It is, however, becoming increasingly difficult to distinguish what, in insurance terms, amounts to piracy. Some so-called acts of piracy may actually be considered more as acts of terrorism, and will therefore be excluded from P&I cover and fall within the scope of war risks cover. Whenever a collision occurs, the priority must be the saving of life. Then, attention can be turned to securing the vessel and her cargo. Many forms of hull and machinery insurance, such as standard English, Scandinavian, German, American, Japanese, and French hull policies, provide liability cover for property damage arising out of a collision with another vessel. However, the extent of the hull cover for collision liability varies considerably according to the conditions of the particular hull and machinery policy. In general, where a specific liability is not covered by the hull and machinery policy, it is covered by the P&I Association. For example, standard hull and machinery insurance does not cover liability for death and personal injury or liability for oil pollution. Such claims are handled by the P&I Association concerned. Click here to see a brief summary of the information a master should note in the event of a collision. The master should endeavour to record the extent of the damage sustained by each ship, the other vessel's name, IMO number and port of registry, the prevailing weather conditions at the time of the collision, including visibility, the exact time of the collision and any discrepancy between the time noted by the bridge and engine room, the position, course, speed and propeller revolutions of one's own ship at the moment of the collision, any alterations to course and speed immediately before the collision, including the exact times of such alterations, any signals given by one's own ship and any signals given by the other vessel, including VHF communication between the two ships, the bearings of and distances between the ships prior to the collision, and the helm and engine manoeuvres before and after the collision and the times of such manoeuvres. Some forms of hull and machinery insurance provide cover for liability for damage to fixed or floating objects, such as berths, piers, fenders or buoys. In general, however, where such liability is not covered by the ship's hull and machinery insurance, it is covered by the P&I Association. In such an event, the master should contact the owner and the local P&I Association correspondent for further guidance.